Welcome to the Probate Nation. This show is part 2 of a 3-part series covering the typical initial probate consultation with an attorney. To put it simply, this stage of the consult seeks to determine who gets the money, honey, when the estate is ready to settle up. To make that determination, we focus on these key questions. Are the total assets to be probated less than $50,000? Is there a will? Who are the stated beneficiaries in the will? Or who are the intestate beneficiaries if there is no will? Please welcome back our returning guest, attorney David Nur. David is a partner in the Ray Law Firm where his practice focuses on estate planning, probate, estate and trust administration. Together, we're going to answer those key questions and much more. So David, let's jump right into this. Now we're into the whole stage of a consultation where we're trying to figure out, how, what happens or what documents govern the disposition of the assets. So tell me a little bit about, we're talking about the typical estate documents. We got a will or no will, revocable trust. What are we talking about here as far as documents we should be looking for? Right.
So I guess the one most people are familiar with is a will or a last will and testament.
Sure.
So that's one that you would kind of look for, is to tell you what to do with decedent's property and who's in charge of making that transfer of property to the named beneficiaries.
Sure.
You could also have no will, which also lets you know what needs to be done, because Virginia has a plan for somebody with no will. There may be some things known as will substitutes that dictate how the property is supposed to pass. So a popular one used in estate planning is called a revocable trust, and that's an agreement that sets up how the property is supposed to pass and who's supposed to be in charge of doing that. And then there's other will substitutes like joint ownership with right of survivorship, or we have beneficiary designations and payable on death designations as well.
So there's a lot of different tools here to actually figure out who gets the money, so to speak. So let's talk about there's no will, okay? What happens if someone dies without a will in Virginia?
So as I touched on, the good news is everybody has a Virginia estate plan. Virginia has one for one. Yeah, it's in the statute, and it says what happens to somebody's property if they die without a will.
So what is the plan that Virginia's drawn up then? I kind of like to know the answer to this question.
A very important question.
And who would be the beneficiaries?
That's right.
So who gets the money? We need to know that.
Yeah. So who gets the money if you die in Virginia without a will? It goes up and down your family tree looking for your closest living relative. So if you're married and have no children, the beneficiary is that surviving spouse, if you have one.
Okay.
If you're married and if you're married with children, but the children come from that marriage, it's still the surviving spouse. That's a common one. But if you're married and maybe it's a second marriage, and you have a spouse, the spouse from the second marriage and maybe children from a prior marriage, then there's a division where it goes 1/3 to the surviving spouse and then 2/3 to the children from the prior marriage. So it basically goes up and down your family tree looking for your closest living relatives, and then there will be divisions based on who and at what level of closeness to you that person is.
So I guess that would be something to be of concern. If someone's had a second marriage, then I guess the concern is to make sure we don't end up with that default provision where, my spouse passes away and we have children, she has children from a prior marriage, then I'm not going to get 100% of the estate. I'm only going to get 1/3.
Right.
And that would be probably surprising to some people.
Absolutely, I would imagine. How about let's talk about, and switch gears here. Let's talk about the will, the last will and testament, Richard.
Okay.
What is a will?
Well, basically, it's a writing. It's the formalities surrounding a will are fairly well set out in the statute. But they can go to the very formal to the very informal. So Virginia has adopted some statutes that allow us to prove the will from some of the most minimalist written documents. Okay, but the formality by which you execute those can be important. Okay, so but it can be a challenge sometimes. Depending upon whether you follow all those formalities to get that will actually accepted by the court. So I think you have to be, A will is not something I think you want to undertake to do on your own, although you certainly have the ability if you are a do-it-yourselfer. The internet offers lots of opportunities, but there are formalities that you want to be very careful are followed. And probably one of the most important is to have a self-proving affidavit attached to that will to facilitate the use of that will if we need to go ahead and take that will to probate. So those are some of the things that would be that come to mind as far as the whole will process. Okay, now I would ask you now. We want the written will. We look to have the written will. We hope to have that document in all kind of proper form. But what happens, if we don't have that self-proving affidavit attached? I mean, I think that's one of the things we talked about. And there are ways in which to get that will proven, even without the self-proven affidavit, provided we have the original will.
That's correct.
There's affidavits that we can use. There's actually we can get witnesses. It's not necessarily too cumbersome, but there is a process. That doesn't involve actually having to go to court. You can actually take those affidavits directly to the probate office. Now, David, what happens if we can't find the will, though? We can't find the original will.
And this happens more often than you think. I mean, I guess it's not that hard to imagine somebody does this planning and then they stash it away. Maybe they move 3 times since they had the document drafted. So they lose it along the way. And so there's 2 things that could possibly happen here. One is, can you find a copy of the will? Because if you can find a copy of the will, then there's the ability to potentially present the copy for probate. But more often than not, you can't find a copy. You're ending up with no will, and you would then have what's called an intestate estate, which means that the person died without a will, and there's a way to administer those types of estates as well.
So places, though, we should look for the will, if I'm looking for the will, even if I'm looking for a copy, is safety deposit box.
Yep.
A lot of times, reaching out to the lawyer, if we happen to know who happened to have been the family lawyer, they may have known. There may be, sometimes people will actually take their will and record it in the local court, and there might be there, and there may be a receipt for that.
Yeah, there's a way to lodge it. Fairfax County, for instance, will allow you to lodge your will with them for $2. So
yeah, that's pretty good, as long as you can find the receipt.
That's right. Yeah.
So what about, we talked a little bit about this, if it's in the safety deposit box, I'm looking for that. How do I get it? I can't find the key for the safety deposit box, or I'm not even on the list that could have access. How do I get into it? Is there some process to allow that?
So under Virginia statute, the spouse and children of the decedent are permitted access to the safety deposit box solely for the purpose of discovering whether there's a will in there.
Okay.
So that is permitted. Otherwise, you're kind of waiting until somebody qualifies, and then they can have access as the personal representative of the estate to get into the safety deposit box.
So let's just say that, and let's say they don't have the key. Okay, so they want to go in there. And they're going to be allowed to go in there because they fit the criteria of the proper relatives, but they don't have the key. So how do we get in then?
You have me stumped, Richard. I don't know. I think you'd have to have somebody drill out the box.
There you go. And I think that's that is the drilling out of the box is more often than not is what happens.
I would imagine.
And that's expensive.
Yeah.
That's expensive. So so again, important to keep track of where that key is for folks to know where the key is, so we don't have to worry about that. And also, I guess, important to make sure people are added onto your list so they have access to the safety deposit box, assuming that you trust them to do so.
I had a question for you, Richard.
Yeah.
So we talked a little bit about, you have this will. How do you prove a will?
Well, I mean, the way you prove a will typically is going to be that self-proving affidavit. Mm-hmm. When we say prove a will, we actually prove that it was properly executed with the necessary formalities at the time. Okay, and so the self-proving affidavit, if it's executed, actually then says that the person was signing it appeared to be competent and knew what there was going on, recognized all the people involved, and articulated this was their wishes to execute this document. It's done with it's done with everybody's hand raised, around the table in a lawyer's office typically, or in a bank. and then the notary signs off with everybody, having signed off on that, says attesting to the fact that everybody did that. So that self-proving affidavit becomes a good way to, that's the most common way to prove a will so that it can be admitted to probate. But if you have an original will with no self-proving affidavit, then there are, as we talked about, there are these deposition forms that are forms that the Virginia Supreme Court has authorized, that you can download those and you can take those and get those filled out by the people who were actually witnesses. Now, I've had situations, though, where those witnesses are all dead.
Right.
Okay. But then you may have family members who actually recognize mom or dad's signature, and then you may have to go into court and produce a copy of the will, if you don't, even the original, and actually ask to have them testify. This was signed by my mom and my dad, and this is their signature. And then typically, absent some objection, that the judge would sign an order allowing that will to be go ahead and admitted to probate, and then you take that down to the probate office. If somebody won't surrender the will, though, they can be forced to do so. Does the clerk write a letter about that and ask people to turn the will over? Have you seen that?
Right. So I want to say that you told me a story about a past client where that kind of stuff had to be done.
It did.
So I mean, it's not hard to imagine that somebody who maybe got their hands on the will wasn't totally excited about what they saw in there. Maybe mom and dad had written them off.
So they didn't like who got the money.
That's right. They didn't like who got the money. So it's easy to imagine such a circumstance. So yeah, there is a way. I think first it's having the clerk at the court send a writing to say, you're going to get in big trouble if you fail to produce. And again, it's under Virginia statute that they're required under law to produce the original will.
Absolutely so. Absolutely so. What else we have to talk about as we start working through the documents? Will substitutes?
Yeah, I think, so we touched on this a little bit in our prior episode, but will substitutes are a way of transferring ownership of decedent's assets. And typically with these will substitutes, we're talking about that transfer of ownership happening outside of probate. So it usually is based on either beneficiary designation. So again, if we're looking at retirement accounts, we're looking at who the designated beneficiaries are on those accounts, and upon the decedent's death, that asset would pass to those named people. That's true in life insurance as well when you look at the named beneficiaries on a life insurance policy. You also have forms of ownership that might have some kind of right of survivorship or some kind of testamentary transfer that occurs upon the death of one of the owners. So two of those that we touched on before were joint ownership with right of survivorship, and then tenants by the entirety, which is an exclusive ownership only permitted for married couples.
I wanted to call our audience attention to the fact that and I think they're going to show up on the screen, that we did a show about probate avoidance techniques, the good and the bad. And then just recent, so I would call that to folks' attention as something that they might want to take a peek at. The other thing, we did a recent show with two really smart lawyers talking about these joint accounts and multi-party accounts. And by that I mean, where they name, two or more people as owners, or they have a transfer on death or payable on death designation. And I wanted to share this, as we were preparing for that particular show, I went to one of the local banks that we do a lot of business with, and I said, okay, when someone comes in here and sets up an account and they have a transfer on death designation to their 3 children as a way of passing it, when that person dies, what happens with that money? And the response was actually a little bit alarming, because apparently some banks take the position that any one of those 3 kids that are named as transfer on death designation or payable on death can show up and they can go ahead and collect all of the money.
Right. Certainly not what mom and dad intended.
Now, they may give it to their brother or sister, but then maybe they won't, okay? Other banks, and apparently this was true of the bank that I had contacted, that they actually, if there's 3 people, then if you come in, you can get a third of it, but the other 2/3 has to be collected by the other 2 transfer on death or payable on death beneficiary. So just be careful about those will substitutes. I would again recommend having a look at those earlier shows.
Well, another thing I would say is a concern with will substitutes is there's no contingency planning built into a will substitute.
There's none. That's correct.
Right. So if we talk about maybe you've named your spouse and children in a life insurance policy, and your spouse happens to predecease you, so therefore your successor beneficiaries under the policy are going to be your children, and maybe unfortunately one of your children's predeceased you too, but they had children of their own, so your grandchildren, you would want that child's share to go to those grandchildren.
Typically.
Yeah, but under these life insurance designations, beneficiary designations, they don't have that kind of contingency planning built in. Or what if you have a beneficiary that's named a child who, unfortunately went through some kind of medical emergency and was no longer, had capacity to take and manage their own money. You wouldn't want them to receive that money outright. So there's concerns that can't be quite addressed with these will substitutes.
Yeah, that is a concern, but they're very attractive to people because they don't need to go talk to a lawyer, which is fine. But the what if situation, as we start to kind of work through that, if everything lines up correctly, they work great.
Right.
But if something goes awry and something changes in your fact pattern, unless you get around to fixing it, you may find that things just don't go the way you want, and that can become very, very important. Now, let's talk about transfer on death deeds. This is another tool that has gained popularity, and some states have it, some states don't. Virginia does. Tell me what that is.
A transfer on death deed is a special kind of deed that allows the owner of the property to transfer upon their death their interest in the property to a named beneficiary in the deed.
Okay.
So it's a testamentary document, in that sense, and it's a way of it passing, to that named beneficiary upon their death outside of probate. And so I think it's attractive to a lot of people when it comes to transferring, and it only is specific to that piece of real estate.
Right, and that's good. Now I know there was we talked about this. There's a one of the concerns that I have with that, which is it's a nice tool, but there was a case out of, I think it was Minnesota, where a fellow had been divorced, and he had a transfer on death deed that was payable to his daughter, and so he died. His ex-wife, for whatever the reason, him dying apparently was something that triggered some issues with her, but she proceeded to go ahead and set the house on fire, and the house burned to the ground. So the daughter attempted to collect on the fire insurance on the property, and fire insurance company said, well, you know what? You were not the insured on our policy. And of course, she would have had no opportunity to get her own policy because she would have Dad had only been dead for a short period of time before the house got burned down. So I guess my takeaway from that case and from the transfer on death deeds is just to be sure that we're clear about insurance coverage, that we don't find that we have some issue that caused an event like I just described. It's kind of an egregious situation, but would be a most unfortunate. I'm still waiting to hear from my colleagues out there what happened on that case on appeal, because I certainly got appealed.
Sure.
Well, let's talk about revocable trust. Okay, so we talk about assets that are going to go through probate. Tell me a little bit about what is a revocable trust.
Yeah, it's a very popular estate planning tool. So a revocable trust is a contract, an agreement, and the person who creates the trust is known as the grantor or the trustor, and they're appointing somebody called the trustee to administer the trust, which is going to be a collection of assets that they fund into the trust.
Okay.
And then they name a beneficiary. So there's somebody who's then going to benefit from these assets that are in the trust, and that could be in the form of receiving income generated on those trust assets, or most commonly they use it as a way to pass assets upon their death to these beneficiaries.
Okay. Now, how do assets get put into a revocable trust?
So I often say to our clients, because sometimes this is missed, that creating a revocable trust and using a revocable trust as part of your estate plan is really a two-step process. So the first step is creating the trust, and the second, equally important step is funding the trust. So we're transferring title of assets in the name of the grantor or trustor to the revocable trust, that the trust is then the owner of those assets. So when we're talking about things like a bank account or a brokerage account, we want to actually change ownership, title on those accounts to the name of the revocable trust. If we're talking about other assets that tend to work off of beneficiary designations that must remain in the name of the owner of the account, so like a retirement account, then you'd be counting on beneficiary designations to make that kind of transfer.
And I want to reiterate, you do not want to try and retitle a retirement account into a revocable trust. Please do not do that. Now, assets held in a revocable trust, do they go through probate?
They do not, and that's why it's such a popular planning tool, is because they do avoid probate.
Okay, that's good to know. And so let's talk about some pitfalls and recommendations. Give me some thoughts here about some of the common pitfalls and recommendations that you have or you see dealing with the documents to dispose of assets and then the documents that are used to transfer assets in probate and outside of probate.
So I think, the one I see the most is if somebody is utilizing a revocable trust, the failure to actually transfer an asset into the trust. So this happens a lot of times with real estate. Mm-hmm. Somebody, after creating the revocable trust, maybe at the time they do their estate planning, the house that they're living in will get deeded into the trust so that the trust is the owner of their residence. And then they move several years later, and the new house they buy, they just do it without really thinking about it. They buy it, in their name, and therefore it's not a trust asset. Right. And so you end up with this asset that's in their name when they die. And the same thing is, you can imagine for bank accounts or brokerage accounts that they subsequently open or never get around to putting into the trust.
Sure. I know from my perspective, I think a lot of pitfalls I see have to do with the transfer on death and payable on designation. There are tools that are in a toolbox that, if they're applied appropriately, can be helpful. So for instance, that brokerage account, maybe you don't want to put it in the trust right away, but you could certainly use a transfer on death designation on that account. So on death, the account automatically transfers to the trust, thereby avoiding the probate of that. Mm-hmm. Okay. Transfer on death deeds are similarly, if you didn't want to actually go through the process of preparing a deed that put it into the trust while you're living, you could have a transfer on death deed, but just be cautious about the insurance issue that we have seen flagged, at least in one case so far. All right, well, I think we're at that point, David, we're going to kind of grab some closing comments, some things you want to share with our viewers about this particular stage of the probate consultation.
I think I would really highly recommend that a little planning ahead of time can avoid a lot of issues that we'll expand upon in our next segment as well. But just how critical executing some of these estate planning documents can be in terms of a smooth administration of the probate estate. So executing a will, just doing it as a part of a plan. If you are going to use will substitutes, making sure that you understand how those operate. If you're using will substitutes and a will, how those two work in conjunction to one another so they're not working adversely in terms of your overarching plan mm-hmm. and who you want to receive your property.
Sure. Yeah, I think the if you're going to use a will to dispose of your assets, as many people do, let's make sure we understand where the will's kept, so we don't have to figure. So we don't have to try to figure that out and don't end up with some sort of an intestacy because we can't find the will. And I think the other thing I found is that having a good list of the contact information for all the beneficiaries. A lot of times people will make bequests in their documents. I've seen it myself, and they have all these people which they can be scattered all over the world. And if you don't have good contact information, you're then at the mercy of the internet and some of the search engines there to find people that could be in Europe or Africa or the Middle East or wherever. And having good contact information would be very, very helpful as we work through this process. And the last thing I'd say is that if you're going to use a will as your dispositive document, there are some tools and opportunities to, while you're going to have to do some probate, maybe, that there's ways to kind of minimize that probate depending upon who your beneficiaries are going to be and who your executors are. So something that you have to have a conversation with your estate attorney about when you get to that particular point. Well, David, I want to thank you again, for taking the time to visit with us, coming back again, have a conversation and continue this discussion about probate consultation as we get someone started on their probate journey, as you will. Great public service. You shared a lot of great information from your experiences, and I want to thank you for that.
My pleasure, Richard.
Tonight we learned about the documents you can prepare to dispose of probate assets and the disposition plan Virginia has written for you for those who have no will. That process is called intestacy law, if such documents have not been executed. The goal of this inquiry in the course of the probate consultation is very simply to determine who gets the money, honey. Now that we know what assets need to be probated and who inherits the money in the estate, the final show called Who's in Charge of This Probate Train will address the court qualification process to get appointed to drive the probate train for this estate. This brings us to the conclusion of our show. We hope you found it helpful. Until next time, take care, live wisely, and be safe out there.